Welcome to literary and jury charge practice. Let's get started with some jury charge practice. And the subject of this jury charge is Highway Traffic Act. Ready? It definitely appears that both motorists were driving at a speed lower than the maximum permitted under the Highway Traffic Act, but the fact that the speed of a vehicle is less than permitted by law does not relieve the driver from the responsibility of reducing speed when special hazards exist with respect to weather, visibility, or highway conditions. It was the duty of each of these drivers to keep his vehicle in his own lane of the pavement. This collision could not have happened if each had done his duty in that respect. It is for you, jurors, as judges of the facts, to determine where and how this accident happened and who was to blame. Whether both drivers were guilty of negligence, which substantially contributed to cause the accident, or if weather conditions alone were responsible. Should you find that both drivers were guilty of violation and the violation by each was a proximate cause of the accident, then neither party can avoid liability. All right, now this literary. Ready? The same reporter wrote to me recently. Thanks for my buck up speech. Each time I needed that to focus. It really wasn't as bad as I tried to make it out each time. Now, what should I work toward? I can tell this court reporter likes having a full plate. One student wrote, I am writing cleaner. I feel a pass coming soon. I shouldn't be focusing on what everyone else is doing, right? It's all about me, right? The student passed her 2 certifying tests that week. Another student said, "Wow, you sure took the saddle off that elephant, and I now have to choose a better path." I replied, "Perhaps you do not want to swan dive into the mind games. Simply focus on your strengths and improve your weaknesses." I have not heard this expression. You sure took the saddle off that elephant. I'm not sure what that means. I think it's good. And then, I like that. Perhaps you do not want to swan dive into the mind games. All right, we'll have to get back to that one. Now let's try some jury charge. And the subject of this jury charge is contributory negligence. Contributory negligence. Ready? Ladies and gentlemen of the jury, contributory negligence is a want of ordinary or reasonable care on the part of the person injured by the negligence of another, directly contributing to the injury as a proximate cause thereof. Contributory negligence may also be defined as a failure on the part of a person injured by the negligence of another to exercise ordinary or reasonable care to avoid the injury. One cannot recover damages for an injury to the commission of which he has directly contributed. If the passenger is at fault, whether because of doing something he should not have done, or in failing to do something he should have done, then he cannot recover any damages for injuries he has sustained. If the passenger's negligence has been a proximate cause of his injuries, he cannot recover from another who has also been negligent. So we have contributory negligence, proximate cause, ordinary or reasonable care, ordinary. Commission. Approximate cause. All right, some words to practice. Let's get back to some literary material. Ready? Here we go. New opportunities can begin with small steps. We can each evolve to a better place when we choose opportunities or when we are given ultimatums. Perhaps there has never been a better time to expand your skills. Or perhaps you believe there has to be a secret sauce to reaching your goal, your desired result. Yet you know that once you reach your goal, your tenacity will instantly focus on the creation of the next hurdle. We often use that word, and on to the next challenge. We are not individuals who rest on our laurels. Based on my many years of teaching and coaching, I can say that the normal state of a court reporter's or court reporting student's mind is setting goals and expanding his or her skills. Why am I writing about this now? I want you to know that you are not alone. Attorneys are requesting more and expecting more. Consumers and audiences want more too. The awareness for unprecedented access to an instant record from court reporters, captioners, and cart providers has changed our profession. To our Who Moved My Cheese? Here we go. Now he felt that it was just a question of time before he found what he needed. In fact, he sensed he had already found what he was looking for. he smiled as he realized it is safer to search in the maze than remain in a cheeseless situation. Ha realized again, as he had once before, that what you are afraid of is never as bad as what you imagine. The fear you let build up in your mind is worse than the situation that actually exists. He'd been so afraid of never finding new cheese that he didn't even want to start looking. But since starting his journey, he had found enough cheese in the halls to keep him going. Now he looked forward to finding more. Just looking ahead was becoming exciting. Get back to some jury charge practice. Back to the jury charge on contributory negligence. But before you can find that the plaintiff is barred from recovery because of his own contributory negligence, you must find that his negligence was a substantial factor which, together with the defendant's negligence, proximately caused the accident. If the plaintiff, in the exercise of ordinary care under the circumstances, should have been aware either that the defendant was unmindful of some danger known or apparent to the plaintiff, or that the defendant was not taking proper precaution in the operation of the car, and the plaintiff failed to admonish the driver or failed to take proper steps for his own safety. And if such failure to admonish the driver was a substantial factor in proximately causing the accident, then the plaintiff cannot recover, even though the driver was negligent. But if you find from the evidence that as the car in which plaintiff was riding approached the place of the accident, the plaintiff exercised the care that a person of ordinary prudence and care would have exercised under the same circumstances with regard to admonishing the driver, then the plaintiff was not guilty of contributory negligence. Just a few words I wanted to mention. We had admonished, admonishing, ordinary prudence, substantial, approximately, and I think that will do it. Some words to practice, and that will conclude our literary and jury charge practice.